So I'd like to introduce Connor and Aoife from the Law Commission. They're going to talk to us about the Social Care Review.
Good afternoon, folks. Thank you for your time. My name is Connor Johnston. I'm a barrister specialising in children's social care, and I'm here today with my colleague Ava Jones to tell you about the Law Commission's review of disabled children's social care. But before I get going with that, before I hand over to Ava, who's going to tell you a little bit about who we are, what we're doing and when, I just wanted to start with a reflection from something that Sarah said this morning. She was talking about the tribunal statistics and how shocking those might seem to an outsider, and how your day-to-day experiences look different to outsiders. And I'll just start by saying I am an outsider here. You know, I'm a parent, but I'm not a parent to a disabled child, and I'm basically just a lawyer. And my job over the next year or so is to carry out this review of disabled children's social care, an area of law that is of huge day-to-day importance to your lives, your children's lives. If that review is going to be effective, we need to hear from you. So I'll start off with that reflection and really just to say thank you for having us here today, because that, to me, is the start of this process. So over to Ava, who will tell you a little bit more about what that process is actually going to involve.
Thank you, Connor. Yeah, so who is the Law Commission? Not many people know who we are, but we're a statutory independent body with responsibility for law reform. And in September 2023, we began working on a review of the law on social care for disabled children in England only. And this is a review that the Department for Education asked us to do. They asked us to do it because recommendations were made to them to do so in the independent review of children's social care in 2022. What our review actually covers is in the terms of reference that's on our website, but in brief, we're going to be considering whether the existing legal duties and guidance on social care sufficiently meet the specific needs of disabled children and their families. So it's quite a broad review, and what we mean by social care are those things you can get from local authority children's services, children's social care teams, within the home or in the community to promote the needs of disabled children and their families. So things like short breaks, personal care, adaptations to the home, and many other things. So we're not looking at SEN provision from education teams, although there's, of course, overlap between social care and education. But, of course, like social care is part of the EHCP process, it's Section H of the plans, so we will be looking at the SEN system as it relates to social care for disabled children. It means we can't fix or make any suggestions on how to fix all of the various issues with the SEN system, but there are, of course, overlapping issues which we will be looking at. In terms of when, we're currently at what we call the pre-consultation stage. So this means conducting a lot of research and starting to talk to lots of parents, charities, local authorities, regulators, academics, the judiciary, and many other people to get an idea of the issues children and families are facing in relation to social care. And all of this will inform what we put in our consultation paper, which will contain provisional recommendations for legal change, which we hope to publish in around June to July this year. Once that consultation paper is published, we'll have a 3-month consultation period where we'll do much more engagement with all of you and anyone else interested in the system to hear what people think about our proposals. And I'll cover how you can get involved in that later in the presentation. And finally, after the consultation period, we will publish a report with final recommendations to the government on how we think they should change the law in this area. And the government do have to respond to our recommendations within certain timeframes. That's everything, I think.
Thanks, Ava. So what I wanted to do for the next part of our presentation is just give you a bit of an idea of the issues that have been emerging from the review so far and what we think about them. Now, all of these things will be things that we put out for consultation. They're not things we've made our minds up on. But as I go through them, what I'd invite you to do is just think to yourselves, are we asking the right questions and are we thinking along the right lines when it comes to the answers. So I've started off with what I've called some of the big picture issues. The first is just that the law is far too complicated. To be honest, I don't need to consult you on that. The law is far too complicated. That is not a question. There are over 30 bits of legislation and guidance which dictate what disabled children can get and from who. You cannot just put into Google, what is my child entitled to from social services, and get a clear answer. And in 2024, that is not acceptable. That needs to be clearer, and that is part of what we are doing. Part of us overarching all of this is we need to make the law simpler and more accessible. Second one is something that Anna touched on obliquely in her presentation this morning. It's about whether we can or should separate the functions of meeting the needs of disabled children from safeguarding. Because what a lot of parents say to us, parents of disabled children, is we ask for help and we are treated as if we are doing something wrong. If we get an assessment, a social worker might want to interview. They might want to interview a child on their own. They might want to check their bedroom. In some cases, might even be checking fridges, mattresses. And often, if we're offered anything at all, it will be a parenting course. So what's happening there is the conflation of these two separate functions, two really important functions, but they're different. Safeguarding the needs of a disabled child is not the same thing as meeting and promoting those needs. So do we need to make those functions separate? A lot of you would say yes, but if we do that, what are the unintended consequences of that? Because one of the positives about the current legal framework under Section 17 of the Children Act is it's not just about meeting needs arising from disability. There's a whole lot of other stuff you can do within that. For example, meeting needs arising from poverty. One of the statistics Anna alluded to earlier that I found most shocking today was the 37% of parents who couldn't keep the heating on or had to go without meals during COVID to meet those children's needs. So if we were to have a separate statutory framework for meeting disabled children's needs, would we make it harder for social services to step in? I've got a question there.
You said that like having it different. I'm literally going into social care myself now because we were told we couldn't have a social worker. It's not been negative at all, but because my son only categorises as moderate and not profound to severe, but he is very complex, he only gets a genetic social worker, and I wasn't bothered with the experience. It was positive. She said, well, I don't know what break time plus is. But she went away, so I don't see that as negative. So if you change, like, say, the statutory law, would it change the criteria of our children that are so complex and misunderstood being able to have a disability needs social worker? Because most generic, I don't mean that in a disrespectful way, but that's where the safeguarding comes into it, because it's generic. Generic means, like everybody, everything. And
We can hear.
I didn't disagree with like that criteria when there's not enough in the public purse, but the law should it's so complex that it's making everything else complex. So if you don't change the law, it's never going to get better, and it's never going to change. So it's like I'm massive on law. I studied it for 6 months at A level. And I'll tell you something, it was the best thing of my life. I haven't got a certificate to prove it. You know what I mean? And it's just, for this type of thing, it will be life-changing, and I can't see no negative consequences. Because I don't think the law...
Thank you.
I just don't think the law is accommodative of anybody.
There's a couple of specific points I'm going to come back to that you've touched on there. So one of them is eligibility criteria, and the other is about the expertise of the people who are working with your children. So I'll come back to those in due course, but thank you. That's basically, this is the stuff we need to be thinking about. This is why we need to hear from you. Point 3 on the slide is about whether or not we should try and integrate SEND more closely with social care for disabled children. Ava said at the beginning quite rightly that these are different things, and our remit is to look at social care, not SEND. We can't rewrite the Children and Families Act 2014, but equally there's a lot of common ground. Assessments, plans. Is there more scope for us to be doing things concurrently so you're not having to tell your stories over and over again? That's the kind of thing I'm grouping under that heading. Assessing needs. what should an assessment involve? Well, it's that point again about it certainly shouldn't involve having to tell your story over and over. Is there more scope for self-assessment, where you as parents are the experts of what your child needs? Maybe you should just be able to say to a local authority, this is what their needs are, and that can be a form of assessment. That's something we need to think about. Point 5, coming back to the contribution we've just had there, is about expertise. A really common complaint from the parents we've spoken to so far is that those who are assessing their children either don't have expertise in disability generally or don't have expertise in their specific child's disability. The most extreme example of that we've heard so far is social workers or assessors trying to assess the needs of non-verbal children who don't use or know about the specific communication method that child knows. So how on earth are they going to be able to hear that child's voice? The answer is that they're not. So how can we ensure that social workers, assessors have access to that expertise? That feeds into the next point, which is how do we make sure that you and your children are listened to during the process? I've just given you an example of how children can be left out of the process, but you yourselves are often left out of it. Parents are often excluded from participating in meetings. If their voices are heard, they're not always listened to and taking them seriously. How can we change that culture? Something that Mary said in her session before the lunch break was that she's been characterised in the past when she has put her voice forward as being angry, as being difficult, as being troublesome. And it was clear when she said that those words weren't uniquely applied to her, then that others in this room had been accused of exactly the same thing. So how can we shift the culture away from that? I think there's a question there, but before I move on.
Oh, thank you so much for taking my question. Paula from Stockport Packs. I just, this is a really great piece of work, and I'm really glad this is, up for review. I think that, as with everybody, social workers have a really difficult time with providing assessments because they can't give the outcomes that they're looking for. So we can provide things like assessments and offer short breaks, but then we have to have somewhere to send families to. And if they're not funded and in each other's locations, then you're basically offering someone a chocolate teapot. So you can go through all the paper exercises you want, offer assessment, but you have to be able to have something at the end of that to offer. And statute assessment, I guess, can only be offered when there's something at the end of it to receive that is funded by statute and the state and funding by local government, not by kind-hearted business people. There's got to be something state-funded for short breaks, for these services that is there to catch these people in their time of need. That's proper social care.
Thank you. I think that speaks to two of the points on this slide, eligibility criteria, point 7 and point 9, how do we ensure that the services are there? But obviously the elephant in the room you've just alluded to is money. And that's the backdrop to all of this when we've got 30% of local authorities in the north on the cusp of bankruptcy. And one of the things we're trying to capture as part of this review, as part of the economic impact assessment we'll do alongside it, is the idea that by spending money earlier on, helping children earlier on, you are much more likely to avoid them having to go into residential placements, having to go into care, having to go into the criminal justice system. And if we can make that case, which Josh McAllister tried to do, that spending money early on can save a great deal down the line, then that, I think, is at least a partial answer to the lack of resources. There's a few other questions. Is it all right if I carry on with the presentation, come to questions at the end, just to make sure we can get through everything?
Session, so we'll try and see what we can do at the end, but if we don't get around to all of the questions today, we will try and arrange for them to take, and we put them on the find the parking, and if we can't do that, then we'll try and get something to you through our feedback sessions. Thank you, everyone.
Thank you. We've got 12 minutes, so we'll see how we get on. If there is time, I will try and take some more questions. But point 7, eligibility criteria. Children's social care, it's one of the only types of state provision for persons with disabilities that varies from area to area, where there is a postcode lottery. If you think of other forms of state provision, adult social care, PIP, DLA, continuing health care, all of those things are administered by means of eligibility criteria which apply wherever you are in the country. Children's social care is different. There is a postcode lottery where what you get depends on where you are. And there's a real question mark over whether that is right. If you have a disabled child you care for and you move from Birmingham to Solihull, your child's needs have not changed, and yet by moving local authority area, whether those needs are met may have changed. So we need to think carefully about whether we move away from that system, that local system, towards national eligibility criteria, which is what we have for adults. Point 9, how do we ensure that the right services are available? And that speaks to the last question we just took, is there's no point in doing an assessment and deciding whether somebody's eligible if a service isn't actually there to meet them. And we come across that most starkly in relation to the parents, more than the children, in relation to short break provision. We've heard of parents who are at their wits' end with sleep deprivation being offered gym memberships, being offered head massages, being offered Tai Chi, services they cannot possibly take up. And even if they could, it's not going to fix the underlying problem, which is that they need a break, they need help. So how can we fix that? Is that to do potentially with assessing local needs, not just assessing a child, but looking at needs more generally in the area and having duties to make sure there are commissioned services to meet those needs? And then finally, to finish up, remedies. By remedies, what I mean is, what can you do when it all goes wrong? Well, there are various routes that are hypothetically available. Hypothetically, I say. I mean, everybody has access to the complaints process, the internal complaints process, but what we hear is it doesn't always function fairly, it doesn't function quickly. Complaints to the Ombudsman often result in decisions simply being passed back to local authorities and not necessarily the underlying problem being solved. Appeals to the tribunal, well, we know they're very successful, but they take a long time to get there, huge battle for parents, and this is only a remedy in relation to social care if your child has or may have special educational needs. For children with social care needs who don't have SEND, this isn't even an option for them. And then judicial review. That is a hypothetical remedy that is available in the same way as, well, famously as the Ritz Hotel is. It's not something that is literally accessible to all. There are legal aid deserts around the country where you simply cannot get a lawyer to help with this kind of thing. So the remedy system isn't there for everybody at the moment. So what can we do to make it function more effectively? So that brings to a close the themes that we've been thinking about. How can you contribute? I'll pass back to Ava to tell you that.
Yeah, so as Connor said, it's really, really important to us that we hear from parent carers throughout this review and at all stages of the review. And so there are a number of ways to get involved. So the first is to respond to our consultation when this is published around June or July. And you can respond individually or you can respond on behalf of your forum. And we'll make sure that the link to the consultation and the different documents that come with it are circulated to all parent carer forums. You can also speak to us today. I'll be around after all of the talks later. You can email us at that email address there, which I'm sure we'll pass on as well after the conference. And then we're running a session in our pre-consultation stage, which I think is full now with NNPCF parents in March, but then we'll organise further online discussion groups during the consultation period to make sure as many voices are heard as possible. I'll pass over to Connor for the last slide.
Thank you. And yeah, on those points, it's 1 and 5 are the really big ones. Start thinking now about how you might be able to coordinate your local forums to respond to the consultation when it lands. And point 5, if you want to be involved in the discussion groups, then be on the lookout for NNPCF communications so we can get you into the room for those. Finally, I just wanted to stress that we are not a faceless bureaucracy carrying out this review. We are a small team of people, and we are here for as long as it takes carrying this out, and we need to hear from you, and we're grateful for that opportunity. Thank you. Yeah. Look, we've got 7 minutes left, so a few questions. 3? Okay.
Hello there. Thank you very much for that. You mentioned like 20 different pieces of legislation, but most children's social care departments are based around the Children's Act 1989, which is obviously 35 years old and considerably out of date. I think that a lot of the problems that parents face with the law is not around the law, it's around the implementation of the law. Yeah. Mental Capacity Act, reasonable adjustments under the Equalities Act, the Children and Families Act 2014, the Care Act 2014, none of these are implemented correctly. And to give out another set of guidance without the practical understanding of how local authority budgets are going to be able to implement that is just another layer of bureaucracy and another layer of legal legislation that comes in that social care cannot deliver, and parents then demand that that's their rights. How are we going to look into the financial implementation of these laws that, one, are already there, and two, that are coming in from this?
So I'm going to pass the buck slightly on that one. Ultimately, how much money gets put behind this is going to be a matter for central government to decide. And all we can do is report on what we think needs change and try and make the case that it is worth doing. But your point that the law's often there and it's not applied, I agree with that. And I'd add another piece of legislation to your list there, is there's some really, really important stuff to do with social care in the Children and Families Act 2014, which isn't implemented. So that doesn't mean that that doesn't mean the fact that the law is there already doesn't mean that further legal change won't help. What I'm thinking as a lawyer when I see that the law is there but it's not being applied is how can we monitor it more effectively? How can we make more accessible remedies so where that is the case, we can fix that? And when I talk about the complexity of the law, what we want to do is simplify things. I'm not talking about changing things that already work, but we still need to make it more accessible. So if it is clearer, both not just to parents, but to local authorities, what the law actually is, I think there is a better chance that those things that are already there but aren't working will be applied correctly.
Thank you. There's lots and lots of hands up, and I'm not going to get round everybody, so I'm going to take one over here, and then I'll go to the gentleman over there. If you haven't had your question answered, please do drop us a line, speak to the people afterwards, and we will try and make sure that any questions we don't get to answer will be responded to.
Thank you. My name's Anila, and I'm representing the Manchester Parent Carer Forum. My question is related to my experiences with parents who have accessed adaptations, disabilities facilities grants, and should there be a standardised eligibility criteria that is more objective and not subjective? What we've heard from parents is their experiences is that there isn't transparency. So the people that are coming to do the assessments, they're not turning up with any sort of criteria or any kind of conversation as to what the need should be. It just seems to be a visual inspection, a 10-minute conversation. Nothing about what the needs are of the child. Nothing's written down. Nothing's formally standardised. So the parents get a decision, no, but not any answers to why, which criteria they didn't meet. So is that something you're working on as well, is like creating a standardised eligibility criteria?
It's the kind of thing we're thinking about, absolutely. There needs to be more objectivity in the decision making as to whether you get disabled facilities grants, but there's other problems there as well. Part of the problem you just identified about the local authority coming to look at whether you need a grant and not really knowing or asking about the child's needs is that disabled facilities grants are administered by local housing authorities, not social services. So maybe they should be administered by children's services instead, and that would eliminate some of that. And then the problem Anna alluded to earlier is that we have a cap of £30,000 that might have been generous when it was first put in place, but doesn't buy you a whole lot of adaptations these days. That certainly needs to be looked at. And by bringing it in-house into children's services, and this is something we're thinking about, not something we're wedded to, that might make it easier to top up the money on a discretionary basis where it's needed to eliminate the problem that Anna mentioned earlier, where the parent was being asked to sign a blank cheque beforehand, which can't be right to meet the top up.
Okay, thank you. I'm Paul Watson. I'm from Gateshead Parent Carer Forum. You said at the start that your criteria that you're looking at services for disabled children from a local authority disability team. But my question's more about the children who receive social care from other organisations. For example, some children with most complex needs, their provisions classed as being above the threshold of what a local authority can lawfully provide, and so they receive their social care provision from the NHS through children's continuing care. So I was just wondering why that's been excluded from the work that you're doing, and also if there is anything else that is being done to address, because it just seems counterintuitive for the children with most complex social needs to not be included in a review.
Yeah. I can see the force in what you're saying, and I'm sorry that there's not a lot we can do about that. Our terms of references are limited to social care from local authorities, so accepting entirely what you say about the most complex needs being dealt with the NHS, we are not allowed to stray into that territory, and the best I think we're going to be able to do, which might be of some help, although it doesn't meet your concern, is at least clarify the line between what is the responsibility of health and what is the responsibility of social services. The reason that the terms of reference evolved in that way is because Josh McAllister's independent review of social care wanted the Law Commission to look specifically at this area, and it wasn't envisioned that it would look more broadly. So unfortunately the boat sailed on that one, but in saying that I don't mean to diminish the importance of what you're saying.
Sorry for my comment, I just want to say, could that be a recommendation from the review to say that that is an aspect that should be looked at?
I think it could. I think if enough parents are coming to us and saying, you're missing a trick here, this is what really needs looked at, then it would be remiss of us not to flag that in our report. So if others in the room share your view, then tell us. Thank you. Okay, I think that brings us to time. Thank you very much.
Thank you both very much. Everyone really enjoyed it, and some really good questions as well, so thank you everyone.